Welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the court and the opportunity to ask questions. In the trial of Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi, the trial panel on the 11th of April ordered the continued detention of Hashim Thaçi and Kadri Veseli, finding that there continues to be a risk that the accused may obstruct the progress of proceedings and/or commit further crimes. The panel noted that even though the prosecution does not intend to call further witnesses, the names of highly sensitive witnesses have been disclosed to the defense, which increases the risk of such sensitive information becoming known to the public. The panel highlighted that such a risk could not only materialize before witnesses are due to testify, but also after they have testified, given that many witnesses have protective measures and their identity should not become known to the public. On the 11th of April, the appeals panel denied an appeal by the defense of Jakub Krasniqi and Kadri Veseli and ordered the parties to file public redacted versions of their respective submissions. The defense had alleged that it suffered prejudice because the trial panel, in their questioning of a witness, referred to a witness statement that the prosecution had announced it would no longer rely on at the trial. The appeals panel reminded that the defense had been in possession of the said witness statement and was therefore fully familiar with it. The panel highlighted that the rules allow a trial panel to put any questions to a witness that are deemed necessary for the clarification of their testimony or for the discovery of the truth, provided that it does not lead to the apprehension of bias. The panel found that the transcript of the hearing in question clearly showed that what was tested by the trial panel was the credibility of the testifying witness, which did not cause any prejudice to the defense. On the 11th of April, the trial panel approved suggestions by the prosecution, the Witness Protection and Support Unit, and Victims' Counsel for a lesser redacted version of transcripts of two witness testimony, and they reclassified the remaining portions of these transcripts as public. On the 15th of April, the prosecution formally closed its case. On the 16th of April, the defense teams in this case jointly notified the trial panel that they intend to file a request for the dismissal of some or all charges in the indictment. The next steps in this case will be discussed at a status conference scheduled for the 23rd of April, starting at 10 a.m. In the case of Hashim Thaçi, Bashkim Smakaj, Fadil Fazliu, Isni Kilaj, and Hayreddin Kutsi, on the alleged influencing of witnesses, the pretrial judge on 14th April issued her decision following a ruling of the appeals panel last week, in which it decided that the third form of incitement provided in Article 32.3 of the Kosovo Criminal Code is applicable in this case. The appeals panel had returned the matter to the pretrial judge to assess whether the evidence supports the confirmation of an additional mode of liability that was initially rejected by the pretrial judge. The pretrial judge recalled that, based on the supporting material, Mr. Thaçi, as the leader and main beneficiary of the obstruction efforts, incited the commission of these offenses by tasking Mr. Smakaj, Mr. Kilaj, and Mr. Fazliu to approach different witnesses, repeatedly and purposefully revealing protected information to them and revealing the identity of protected persons to Mr. Kilaj and another person. In addition, the pretrial judge found that the supporting material revealed that Mr. Thaçi encouraged and urged Mr. Smakaj, Kilaj, and Fazliu, within their respective groups, to receive and memorize his precise instructions and to contact certain witnesses for the purpose of unlawfully influencing their testimony before the specialist chambers. In the view of the pretrial judge, the deliberate acts and encouragement and urging, as detailed in the confirmation decision, demonstrate Mr. Thachi's direct intention to incite the commission of attempted obstruction of official persons by Mr. Smakai, Mr. Kilai, and Mr. Fazliu. As a result, the pretrial judge confirmed the additional mode of liability vis-a-vis Mr. Thachi under Article 32.3 of the Kosovo Criminal Code and ordered the prosecution to submit a new amended confirmed indictment by no later than 16th of April. The pretrial judge expressed the view that a further initial appearance by Mr. Thachi was not necessary, considering that only a new form of incitement was added to the indictment and not a new count, and that Mr. Thachi has been informed about both the offense and the basic form of incitement. However, the pretrial judge noted that Mr. Thachi's position in relation to the added mode of liability must be formally recorded, and he was therefore invited to enter a plea. Given that Mr. Thachi had entered his initial plea of not guilty in writing, the pretrial judge ordered him to enter a plea on this matter in written form by the 24th of April. Should Mr. Thachi decide not to enter a plea, the pretrial judge will plead not guilty on his behalf. Should Mr. Thachi wish to be informed in open court of the additional form of incitement to the existing count and present a plea on this occasion, he may submit a request to do so by the 24th of April. The pretrial judge also ordered the registrar to promptly serve the new amended confirmed indictment on the accused, as well as on Mr. Smakai, Fazliu, Kilai, and Kutsi in Albanian. In the same case, on the 11th of April, the pretrial judge granted a request by the prosecution to disclose 2 additional items to the defense that they intend to use in trial, finding that the prosecution demonstrated good cause warranting a variation of the initial 17th February deadline. The pretrial judge further found that the disclosure will not cause any undue prejudice to the defense. The prosecution had explained that the additional items will improve the overall understanding of previously disclosed evidence. The defense has raised no objections regarding the proposed disclosure, and the pretrial judge considered that the defense will have sufficient time to study the additional items as they are limited in scope. On the 15th of April, a decision by the pretrial judge from the 27th of March became public, in which she rejected a request by Haji Shala for temporary release based on compelling humanitarian grounds. The pretrial judge pointed out that Mr. Shala could not demonstrate a close relationship to the relevant person in the request, and also did not provide the relevant medical reports. As such, she concluded that Mr. Shala did not demonstrate the existence of exceptional and compelling humanitarian grounds to justify his temporary release. Are there any questions before we conclude the briefing?